Pushpa, thanks so much for making the time to talk to us today.
Asha, thank you so much for having me on board, and JD too.
It's our pleasure. We want to get down to this topic and get as many facts as we can. So we're familiar with cases of mothers losing custody and rights, equal rights, whatever kind of rights that come up in the news, but not with fathers who have the same struggles. What's the reality of the situation here in Malaysia?
Yes, you're right. You see, when a mother loses custody, it is a big thing. Everyone would like, why? How did this happen? It's just so unusual, you know. Everyone talks about it. But when a father gets custody of a child, it's like, how? How did that happen? How did he ever get custody of a child? What went wrong? You know, it's that kind of sentiment, you know. But I think at the bottom line to all this is we need to understand what the law is, and what is the position of the judges when they make decisions. So we have got two situations here. We deal with children who are under 7 years old and children above 7 years old up to the age of 18. Now, with regards to children under 7 years old, we have got what we call a rebuttable presumption in law. This is actually provided for in the Law Reform Divorce and Marriages Act of 1976. That's a piece of legislation that every family law practitioners would carry around, and that's what we use. It's our little Bible, basically. So Section 88, Sub 3 of that particular act actually says that there shall be a rebuttable presumption that it is for the good of a child below the age of 7 years to be with his or her mother. So that's the first limb of that particular section.
What does that actually mean in layman's speak for the rest of us who don't speak lawyer language?
So what it really means is, if the child is under 7, give it to the mother. The mother is the best to look after the child. Now, if you think the mother is not good, then you show me why the mother is not good. So where the mother is concerned, all she needs to show is that she is the mother. That's all. That's the legal criteria that's required of her. So long as she is the mother, she's entitled to custody of the child. Whereas where the father is concerned, not only does he have to show that he's a good parent, but he has to go one step further, which is a real uphill task, to show that the mother is unfit, to break that presumption. Yeah, there's a presumption. Mother is good for the child it is good for the child under 7 to be with the mother. So that's the presumption. We all have to accept it, that is it. But to break that presumption and to say that no, she is not good for the child, or it's not good for the child to be with her, we need to basically, or the father basically has to attack the mother.
So it's not good enough for the father to be also good for the child. That's not enough. He has to actually attack her and break it down.
But in this case, it sounds very much like it's very zero-sum. That means it's very binary. It's either one person gets custody, right?
Yes, it's just a situation where the mother gets custody, full stop. That's it.
Right, but if the father attacks and then he wins, that means the father gets custody, but the mom doesn't, right? So it's either one or the other. It's never like two sides, right?
No, not at all, not at all. So this is at the point where the child is under 7. We're talking about that particular category at the moment. So now here, you need to show that the mother is unfit. How do you show that the mother is unfit? You can either attack her mentally or physically. She's either mentally unfit or physically unfit. So that's what I mean, that it is an uphill task for the father. So when he does prove it, so for example, when you go to court, usually you can have a custody battle in the High Court, or you could have a custody battle in a divorce proceedings. It's two separate things. Yeah, you can either start a separate proceeding on custody without worrying about divorce first, or you start your divorce proceedings and talk about custody rights in the divorce proceedings. So whichever way, the High Court judge would be looking at an ocean of evidence. She is the person who's going to look at all the evidence surrounding that decision that she has to make, as to whether or not the father has rebutted that presumption that the child is best with the mother. So that is not easy for the judge. But when she does make that decision, assuming that she makes it in favor of the father, well, in all probability, the mother is going to appeal to the High Court, to the Court of Appeal, and the Court of Appeal is then going to again look at the law. And usually, if it's a finding of fact that the High Court judge makes, and she substantiates her reasons carefully as to why she has granted custody to the father, then there is a chance, okay, there's a very good chance that the Court of Appeal will go along with it. But there is also a chance that they may throw out that decision on the grounds that no, the child is under 7, it is best with the mother. So that can happen.
Right. So generally speaking, if we can even put it generally, when a custody of a child is given to, say, the mom, is it usually then meted out in terms of, then we work on sort of shared parenting or co-parenting? Does that ever come into the picture with a child under 7? Or is it just you get custody, you get visitation rights?
Absolutely. Unless the parties consent to a consent order, which means the parties themselves agree, okay, we will agree to joint custody and joint guardianship, but the child will stay with the mother, whereby the care and control of the child is with the mother, but custody is joint. So which means when the custody is joint, they decide on everything pertaining to the child's welfare.
Right. Okay, so generally speaking, how often does that happen?
Very rarely do fathers get custody when the child is under 7. I have had a few successful cases where I've got custody of a 6-month-old child for the father. I have had custody of 3-4-year-olds for the father. So that has happened. But let me tell you this, it is not easy. It is an uphill task. You need a lot of planning. You need to look at the evidence carefully, gather the evidence carefully, and really put up a solid case for the judge to look at.
So what was it that won it for those cases, though?
Sorry, JD, I didn't get that.
What was it that won it for those cases? Because you said there are a few cases where they were 3 and 4 years old when they actually went to the father. What was it about those cases, without giving too much details, that actually won it for the father?
Well, I was able to rebut the presumption by showing that the mother is unfit because of her behavior.
Right.
So behavior issues was one of my fortes in those two particular cases that I fought for custody, the 6-month-old baby and a pair of twins who were, I think, 5-6 years old.
Yeah. I only asked because I'm wondering, that means it's as long as you can prove that they could endanger the child's life, then it goes to the father. So it's either mental, could be financial. They can't provide a safe space for the child or something like that, is it?
Sure. Yes. Basically, it is when we look at the child's best interest, we look at things very globally, the child's education, the health, the child's social behavior, etc. So if you can show that growing up with the mother is just not going to be good for the child, then there is a chance that you can win that, you can break that presumption.
Right.
Now, Pushpa, why isn't sort of the default setting the idea of shared custody, in the fact that for children under 7, as we're talking about, why isn't shared custody a default setting to then be sort of the, how it's done discussed afterwards?
Or default consideration even?
Sorry, what exactly do you mean by that?
Meaning, why is it a default that the custody belongs to either the mother or the father, depending on what can be proved?
And not
why isn't the
that
default
situation.
setting, it's shared custody, or there's a mother and father here. Let's be using this sort of time to work out how the mechanics of how this shared custody
Like a
works.
50-50.
Yeah, I mean, ideally, that's what it should be. And if you ask me, I think the first thing that we should be looking at is the law reform. I do hope that the Fathers Rights Association would now gather more case laws, do more case studies into the various cases where fathers have lost custody, and come up with a good paper, reform paper, to put before the AG chambers, maybe, to reform this particular piece of legislation. It has to go. It is just an archaic assumption. It is so archaic. A lot of countries have moved away from it, and they are talking about shared custody. Let's even go as close as Singapore. Even Singapore talks about shared custody.
Did we inherit this from the British? I mean, is this law from the British times or?
I think actually, I've actually read an article on motherhood, and it's very interesting. Maybe I'll send it to you all at some point.
Yeah.
And if you read it, you would look at where it all started. It all goes back to 17th or 16th century, where women were always at home. Men were out there bringing in the money, working very hard, etc., etc. So when it came to the women, their forte was to produce a child, look after the child, and bring up that child. That was their forte. That was something that they could be proud about,
Right.
because they were not out there working to bring money, but they were there to actually bring up a child, have a child and bring up the child. And that was the only job they had.
I'm so glad I didn't live back then.
but there you are. That's how it just went on into the 18th century. And now we are here in the 20th century, where once again, that is the forte of a woman. Only she can produce a baby, not the men, unfortunately.
Well, actually, now they're growing them in petri dishes. And that's how advanced science is going.
Yeah, we don't know.
They did that with Dolly the sheep, didn't they? Okay, let's talk about children above 7. What's the situation there?
Okay, so once we come out of this presumption, then what the law is we are now moving to section 88 sub 2. And this section 88 sub 2 is very neutral. All it actually says is you take into consideration the wishes of the parents. And the judge shall also take into consideration the wishes of the child. If the child is able to express himself or herself, articulate well, then you can take into consideration the child's wishes. So when you talk about taking into consideration the parents' wishes, what happens in court is basically the father is going to say that I am a better parent. And you will have the mother on the other side saying, no, I am the better parent. So the struggle is usually between these two parents who are trying to outwin each other. They are just basically saying, I'm the better parent. And they have to show that they are the better parent in all perspectives pertaining to that child's welfare. So then only after looking at these things, then the judge would look at, okay, now let me look at what is the child's wishes. That's when the child's wishes come in. If the child is able to articulate well, if the child says, I want to stay with my daddy, and the judge says, why do you want to stay with the daddy? And the child says, well, daddy lets me watch the TV. He's okay if I don't eat my vegetables. He's okay if I don't eat my ice cream. I'm just giving an example.
Yes.
And the mother would say, no, you have to eat your vegetables. Sorry about that. You need to finish your cauliflower or whatever. And you need to go to bed by 8 o'clock. That's it. You can only watch one cartoon. So these are things that the child would put forth to say that, no, I prefer my father. And at that point, the judge should start thinking, says this child doesn't know what's good for him.
Right.
Yeah? So then that she has to give the weight that it's deserved, that little conversation or interview with the child deserves. So it is really up to the judge at that point in time. But there are also very articulate children who very clearly state why they want to live with the father rather than the mother, or with the mother rather than the father. They're quite articulate. And when they are articulate, I'll come to why they may be articulate later, but when they are articulate, the judge would tend to want to listen to the child, because they are afraid that if they make any contrary decision, it would psychologically and mentally affect the child. So they are afraid of that, and so they go along with the child's wishes. So that's what happens in an interview room with the child. So in fact, for example, I have got a child, I represented a boy who went into the chambers to talk to the judge, and he wanted to speak only to the judge. And he didn't even want the interpreter there. Normally the interpreter is there in the chambers with the judge. So the judge finally said, okay, I will speak just to him. And she sent the interpreter out. And what the child did was, he told the judge, can I come to your side? So he was sitting on the chair across the judge, and he said, can I come to your side, please? And the judge said, okay, why not? Come. And he went to the side of the judge. So he came to stand right next to the judge. And he said, do you have a piece of paper and pen I could borrow? And the judge gave him a pen and a paper. And what he did was, he did a drawing. He illustrated his feelings to the judge. And I'm going to show you that piece of paper and what he actually did. This is, can you see it? I'm so sorry. But
it's like a triangle on its side.
It is actually not a triangle. It is actually a V.
Right.
And he describes it by showing this end, where it's the wider end,
like the greater than
the
sign.
greater one, and that point. Sorry, the point is here. The point here, yeah. And he says that when he is with a parent, he feels this way, caught in a corner. And when he's with the other parent, he feels very liberated. And that's the good feeling he has with the father, or the mother, sorry. He actually illustrates it this way. So you see the point I'm trying to make. Some children are articulate. So when the child can actually do something like this, it is very impressive to the judge. And the judge would tend to go along with that child.
Right.
Now, of course, we have situations also where the child may have been alienated. I don't know whether you want me to go into that now.
Yes, let's talk about alienation. It is a big word that's sort of coming up right now.
Right. Yeah, and I know that you actually asked me about Bob Geldof.
Well, yes, because I watched a documentary, and Bob Geldof called it quite literally a state-sponsored child abuse, with the rights of visitation given to fathers instead of equal opportunity to parent.
Correct. So basically, he was attacking the legal system, and he said the legal system was scarring the children by forcing the children away from the father. Father, that's what he said. And I think,
do you agree?
Quite recently, he even went on to accuse the family law of being barbaric and basically kidnapping the children from the fathers.
That's right. Yes. Do you agree with that to some extent?
I wouldn't go so far to call the family court barbaric. That's not right, I think. And I think I do go to the Kuala Lumpur family court regularly and go to the Selangor family court regularly, and the judges there are very nice judges. We have got a very good set of judges, and the decisions that they make, even if it's not in my favor, I have accepted it because a lot of thought has been given to the decisions that they have made so far. So, but what I would say is that these judges are bound by Section 88 sub 3 on the presumption where children are under 7. It is a difficult time for them when they make decisions with that presumption. They have to be so sure when they want to give the child over to the father. But when it comes to children above 7 and between 18, that's again, you can break that category. If you have got a teenage child, 13 years old to say 18 years, it is very difficult not to hear them out. And quite often they are very articulate. But having said that, no, even if the child makes a decision that the child wants to stay with the mother, I think it is so important that when it comes to custody, our courts should move on to grant joint custody for children, generally for all ages. But because of the law at the moment, they have to consider that for children beyond 7 years and up to 18 years. I think the father's input is important. The mother's input is important. The child needs both the parents. And therefore, joint custody is definitely the way forward in dealing with the child's general welfare.
For the best interest of the child,
absolutely,
right? Because at the moment, the best interest of the child can't be the full focal point, because it has to be either or parent. That's what you're choosing and deciding right now, right?
That's correct. That's correct.
So let's go back to what you were talking about, alienation. Can you explain this sort of term, alienation, when it comes to, in this case, father's rights?
Yeah, we talk about parental alienation, and parental alienation usually you would see in a situation where there is a child involved in a very high conflict divorce matter. Yeah, that's where you see it. So this child would be torn. So the child is usually, he usually identifies more strongly to the custodial parent. And that's a sign of alienation. And the alienating parent may either verbally or even maybe physically try to influence the child. And this is where you would have the alienation cropping up. Now, we have got the, what is his name now? Let me just check what is his name.
So
Richard, is it Richard Gardner? Richard Gardner, who is an American psychiatrist. He came up with this terminology, parental alienation syndrome. So then, but unfortunately, the word syndrome was not accepted by many at that point in time, or rather the American Association. And therefore, there was this issue as to whether parental alienation can stand, whether there was enough evidence to show that there is parental alienation. So you need to gather enough evidence to show parental alienation. But today it seemed to be something that's accepted in some countries. Yeah, in some countries where you find that if they find that the mother, for example, is alienating the child, they give the custody to the father. And they find it wrong if it's found that a parent alienates the child, either way, So we have this theory of parental alienation, and yes, it is to a large extent affecting, in my opinion and in my years of experience, it is definitely tilting against fathers, unfortunately. Yeah.
And how do you get proof of that, though? I mean, how do you find proof of parental alienation? Do you put cameras in the house and stuff like that?
No, it's just by the way the child actually speaks sometimes, and you can have a very small child saying, daddy is bad, daddy is this, and daddy is that. And
words that he or she will not be able to use.
Yes.
Just come up with on its own, right? Yeah.
Correct. You can't have a 4-year-old child saying such things. I mean, what would a 4-year-old child know about a mother or father being bad?
Or daddy is a loser and stuff like this, right?
Yes, daddy is mean, daddy is selfish. They come up with some words which does not match their age. And that's not right. And they stand their ground. They would say some nice things about the mother. I don't like daddy. I don't like to go to daddy's house. There is a monster in daddy's house. All sorts of funny, strange,
it's really clear that it's not like there's no gray area.
So, I mean, is there any worry ever, speaking, obviously, I don't mean to sort of offend here in asking this in any way, but is there, how do you know that it is an alienation situation versus something that they have witnessed or seen? Like, how would you discern that?
Yeah. Okay. Like, for example, when I spoke to a young girl who initially didn't want to have access with her father. I spoke to her personally myself. She was about 5-6 years old. And I had a one-to-one with her in my room. And what she said to me is, Auntie Pushpa, I tried talking to my father. I tried telling my father that I don't like him talking bad about my mother. You know, I have tried talking to him because I asked her, did you try conveying your feelings to your father and telling him how you feel? And then she said, I did tell my father, I don't like going to this particular place all the time because the father actually travels a distance to come to see this child. And eventually I convinced her that she needs to push her agenda further. She needs to speak to her father more and tell the father that this is how she feels. And eventually it worked. So now access is resuming as normal, and the child is quite happily going for access with her father. So
Right.
sometimes what I would say to fathers is listen to your child. And I would say the same thing to the mothers as well. Listen to your child. And of course, we have got difficult situations where I know of fathers who have to stand outside the gates of their house to meet their child. And the child would actually say things like, mommy says you have to pay for this, that, and the other. Otherwise, you can't come into the house, or otherwise I can't see you. So you have some clear-cut cases of alienation there. I mean, it is terrible for a father to have to talk to a child across a fence.
Yes.
That is really, really terrible.
Is there any legal recourse in this country for that sort of thing happening? Which obviously it is.
I think it all depends on the judges. We need to move on with the changes in the society. We need to move on with time. At this point in time, we need to understand that fathers equally play an important role in a child's life. Where parents are concerned, fathers are equally feeding a newborn infant. The fathers are equally preparing meals for the child, bathing the child, taking the child for various activities, putting them to sleep. They are equally involved. The modern fathers are equally involved in the child's upbringing. So it is no longer a situation where it is just a mother's forte. We have gone way past it. I mean, I speak for myself. When my kids were young, my husband would wake up in the morning. He would prepare the breakfast for the two fellas, and he would like mess around with them. I mean, he loves doing the breakfast to the point where he will be doing sausages, baked beans, and God knows what not, And I would think, my God, are you crazy doing all this early in the morning? And I'll still be sleeping. I can't be bothered what he does. He would feed the kids and take them off to school, send them both to school, and then he comes back and we both go to work together. He's also a lawyer, by the way, and he's my partner. So this is how it is. And I think I think when the children were young, I would have thought that if we both had a custody battle, I think I would have lost out.
Right.
If we went for a fair play, I think I would have lost out, because they would all just run to him. I mean, I could just be sitting right next to the door and he would be sitting on the far end, and they could run through the door because they have had a fall, and they will bypass me and run straight to him and says, Dad, I've fallen down, I've hurt myself. And he would fuss about it. Whereas I have no time to fuss about it.
Cold-hearted mother. That's what they'd say about me too. So don't worry. I think you and I would be friends there.
Yeah. But the point I'm trying to make is give them a chance.
Yeah.
Give the fathers a chance. And I think I really would propagate that it has to be shared custody. Unless, of course, there are extreme reasons why one of them should not be given custody.
As a female lawyer who assists local and international women's organizations, are you or have you heard concerns around changing the legislation to be geared towards shared custody as a default, or giving fathers more access or custody as well?
We all know that there are many countries out there who are actually moving towards joint custody. and they go on the presumption that it is all equal unless proven otherwise. So they have some provisos, as I said, And like I said, I strongly believe that even in this country, judges may have to start on the presumption that there should be shared custody, unless there are very extreme reasons why it should not be granted. And I also strongly believe, Asha, that children's voice is not there. I mean, they are not heard. And that's where, as also a child advocate, I would actually say that we need to give the children a chance. And in very acrimonious cases, why can't we have a child advocate?
Right? Is there not such a thing as a child advocate or mediator for these sort of circumstances?
Not at all. Unfortunately, none in Malaysia at this moment in time. So in fact, some of us who have been trained in child advocacy have gone around training a lot of lawyers in Malaysia to understand and how they should have the skills as an advocate for child. And we are trying to push that agenda. However, we need to have, of course, the government participating. We have to have the AGC, the judiciary, all the stakeholders coming in to support this fact that children in an acrimonious marriage must have an advocate for themselves. In fact, if we look at the Law Reform Act that we have at the moment, we actually do have provisions for what's known as a guardian ad litem. So you can actually appoint a guardian ad litem, and guardian ad litem can be anybody who is a responsible human being. You could be a social worker, you could be a psychologist, anybody who is a school teacher, maybe anyone who is a responsible person can actually be a guardian ad litem. And then we appoint a lawyer for the guardian ad litem to represent the child. Now, in fact, back in 2011, there was a test case, and it was actually my case. And some of you may remember this case about BN, baby BN. She was known as BN, BIANNE. So she actually spent 4 years in court as opposed to be in the playground.
Oh my goodness.
Yeah, she was actually with her father, battling to want to be with her father. And that was a case that was like, it was actually a high profile case where it was in the papers every day during that period of time. The father was sent to prison. The father was fined because he was breaching a court order wherein the court had given custody of the child to the mother. But the child...
So he was in prison for that, not for anything else?
For hardly about 2 days.
All right, okay.
We got him out, and then because he was not able to pay the fine of 20,000 for contempt of keeping the child. So anyway, what has happened is we actually made an application to court for a guardian ad litem to be appointed. That's the best we can get towards getting a child advocate. So there is an advocate who would be representing the guardian ad litem, who would be tailing the child, who would be looking into the best interests of the child. But the High Court said no, that there is no need for a guardian for a child advocate through the guardian ad litem. Then we took it up on appeal, and on appeal as well, it was not allowed. So in fact, there's a lot of, you can look into this actually, you can click in the name BN, and you will see a lot of information.
Yeah, I'm just checking this out.
But eventually,
low BN, right? Yeah.
Correct, that's right. Eventually, custody of that child went to the father after 4 years of battle.
So she wasn't given the guardian ad litem, is that what you're saying?
Yes, she was not allowed a guardian ad litem or a child advocate through the guardian ad litem.
Why wasn't she, if there is provision for that being part of the process?
Don't ask me. I think My firm tried that back in 2011, and I've not had an opportunity to do that once again. But I think I would encourage more lawyers to use that rule and attempt to have the child represented. Because you see, our system is such, we are not ready for it. Now, if we have a child advocate, who pays for the child? Who pays for the advocate?
I was going to ask you for that, because especially if the child doesn't, if the mother has a lawyer and the child doesn't want to be with the mother, that lawyer is not going to not represent his client, which is the mother who's paying him.
Absolutely. So that's where the system has to be prepared for this eventuality. It has to be an eventuality. So the government, all stakeholders have to look into why not have a child advocate in cases of an acrimonious child custody. I think the judges play an important role. The judges should be the ones to also give their views that this is probably needed, that you will have an independent person who is actually representing the child indirectly through another person.
Yeah, because I mean, if you're fighting for the child, the child has the right to speak.
Yes.
Right.
Yes. So that's very important. And I hope those changes can be made. And I really hope that the new Fathers' Rights Association, and in fact, that is this another group called Malik. They are a parental alienation society. So they too can join forces. And I think they should look into child advocate. For some reason, the women's rights organization are not I don't think they're looking into child advocate as such, but there are some child rights associations who are looking into it. I mean, I belong to a group called CRIB, CRIB Foundation, CRIB Fund Foundation, and we are advocating for child advocates to come in to help children.
What's it going to take for the law to change? I mean, like how likely is it? How fast can it be changed? I mean, what are we really looking at here in terms of the next best step for dads?
Yeah, actually, I also want to share with you, Asha, the problem that we have at hand, in the sense that you need to understand that back in 2019, the statistics shows that we have had about 102,477 divorces. All right. Now, I'm not saying that each of this divorce may have one child involved, but let's even take a very, I don't know whether
ballpark figure.
A low park figure of what? Say 10%? Shall we agree on 10%?
Yeah.
Let's take 10%. If you take 10%, you're talking, and let's assume 10% has got children involved. You're talking about 10,000 over children in a year who are involved in a child custody battle. I don't know. I'm just giving.
It might be higher even.
Yeah. It could
and
be,
that's not counting unmarried parents or illegitimate children.
Correct. So there is quite a lot of children involved in my view, and I think as a family law practitioner, if you ask me, I think it is very important for a family law practitioner to be very rational and not emotional when they deal with their clients. And what is most important is to be principled. So if you have got a mother who's not allowing access to the father, you need to put it right. You need to tell this woman, no, that's not on. You need to give custody. And when you're representing a father and the father is not paying maintenance, I think again you need to put it right. And you say, no, I'm happy to represent you, but you start paying now. Straight away start paying, even if we have not gone to court or if we have not even had a court order, it doesn't matter. You start paying. So you need to have some principles in place, and you need to be skilled to deal with children if you need to deal with children. Now, where fathers are concerned, I think, like I said, the way forward is for them to document their experiences together and come up with a good reform paper. And all of us should help them towards it. This is actually a national problem. A lot of fathers are affected. I'm saying that because I think it is because of the fact ideology that we have that mothers are best and children must grow with mothers. Being a mother myself, I think it has to be, we have to start off on a fairer platform where we talk about joint custody, unless, I qualify myself, unless it is shown that this father is really totally unfit to be, to have custody of the child.
The same way a mother needs
Yes, absolutely,
Yeah.
absolutely.
Equal
Because
playing
you
field,
can have a very disruptive parent. Let's put it that way. You can have a disruptive parent, and you have a disruptive parent, it is so difficult to make decisions for the child. Yeah, so that's there. So we need to really look into the child's rights as well. The child being able to be represented, to have an independent person whom the child can speak to freely and confidentially. And this independent person does his or her homework by looking at all aspects of the child, going to the school, maybe talking to the school teachers, finding out how the child is faring, looking at who is actually taking an interest in the child. Does the father find out what's happening to the child? Does the mother find out? Looking into those factors from the child's perspective. Go to the child's regular doctor, maybe with the parents' permission as well. Of course, you need to have the parents giving permission for the child to advocate. So go to the doctors, find out how the child's health is, because you have silly situation. Even a mosquito bite on the child during access can become a big issue. Or the child came back with a bump, or the child came back with a scar on him. That can be an issue. So even the general vicissitudes of life is made into a major issue in
under the magnifying glass.
literally mountain out of a
Absolutely.
molehill. My God,
Right. Yeah. Well said, Jenny.
Yep.
All right. So change the laws and start pushing for a guardian. What is it? Guardian?
Start pushing for child advocates, whichever way. At the moment, we can still do it with our present law by invoking certain rules and getting a guardian ad litem in place.
Guardian ad litem was the word I was looking for.
Yes. Otherwise, just let's go for child advocates, right? Let's start working towards having child advocates for the child.